Welcome to this explainer on Canadian employment law. You can think of employment law as essentially the crucial, legally binding rulebook for workplace fairness. It is literally the foundation of every single professional relationship you'll ever have. Now, to make this diploma-level overview as practical as possible, we're going to use a real-world hypothetical guide today. Meet Aurora Tech and Bakery. They're an Alberta-based small business running a bustling storefront and a fully remote software team. By following their journey, we're going to unpack exactly how these complex legal frameworks operate in the real world. Here's our syllabus for the day. 1. The Employment Law Foundation. 2. Sources of Canadian law. 3. Balancing rights and responsibilities. 4. Health, safety, and harassment. 5. Contracts and workplace dismissals. And finally, 6. The remote work evolution. We're basically going to follow the entire life cycle of employment at our little Alberta startup to understand these regulations. Okay, let's dive into this. Section 1. The Employment Law Foundation. Before the owner at Aurora can hire their very first baker or software developer, they need to know exactly what they're stepping into. So employment law is the body of laws, regulations, policies, and legal principles that regulate the relationship between employers and employees. But if we really break that down, it's doing two main things. First, it protects workers from exploitation, like unsafe conditions or unfair treatment. And second, it establishes fair baseline minimum standards for everyone. It ensures our business owner can operate effectively, but strictly within legal and ethical boundaries. Now, as Aurora grows, they aren't just hiring one type of worker. A modern business relies on a mix of full-time, part-time staff, and independent contractors. And this right here is a classic legal trap. While full-time staff working regular hours get standard employee benefits, independent contractors are essentially self-employed. Because they provide services under a contract, they generally aren't entitled to those same statutory employee benefits, like vacation pay or overtime. Honestly, mislabeling an employee as a contractor is a huge compliance risk. Moving right along to Section 2, Sources of Canadian Law. Now, what's really interesting about this slide is how we break down where these rules actually come from. In Canada, employment law isn't just one big book. It's this complex mix of federal laws, provincial laws, and collective agreements. Because Aurora is in Alberta, they're governed by specific provincial laws. For example, the Alberta Employment Standards Code handles things like minimum wage and overtime, but they also have to comply with the Alberta Human Rights Act to prevent discrimination and Occupational Health and Safety Laws, or OHS, which dictate hazard prevention. It's basically a multi-layered shield protecting the workers on the bakery floor. But statutory law, the written codes we just talked about, isn't the whole story. We also have common law. Let's translate that legal jargon into plain English, shall we? Common law simply refers to legal principles developed by judges through court decisions over decades, rather than a single written rule book passed by the government. So when it comes to deciding, say, how much reasonable notice an employee needs before being let go, courts look back at past common law precedents to make their rulings. It's like a giant puzzle of past decisions. Which brings us to Section 3, Balancing Rights and Responsibilities. We often think of employment law as just protecting the worker, right? But it's truly a balancing act. A healthy employment relationship is absolutely a two-way street. When you compare them, the tension between the two is pretty obvious. Employees have absolute rights to things like fair wages, safe conditions, and a degree of privacy. But on the flip side, employers also have the right to manage their workplace, discipline misconduct, and protect their business interests. For example, an Aurora employee's right to privacy must be carefully balanced against Aurora's right to protect its business interests through things like confidentiality agreements. And to maintain that balance, employees have strict legal obligations too. An Aurora baker absolutely must follow workplace safety policies to prevent accidents. An Aurora tech worker must maintain the strict confidentiality of customer data. Everyone has to show up, meet performance expectations, and report hazards. It's a mutual contract of respect and responsibility. Next up, Section 4, Health, Safety, and Harassment. What happens when the work environment becomes physically or psychologically unsafe? Well, under occupational health and safety laws, employees have 3 vital, non-negotiable rights. Step 1, the right to know about hazards in their environment. Step 2, the right to participate in safety activities. And Step 3, the right to refuse unsafe work. So if our baker at Aurora notices a commercial oven is sparking and dangerously faulty, they have the absolute legal right to refuse to use it without any fear of being disciplined or fired. Psychological safety is just as heavily regulated. Employers have a strict legal duty to address harassment, whether that's bullying, verbal abuse, or sexual harassment, as well as discrimination based on protected grounds like race or gender. If a complaint is made, the employer must immediately follow these steps: formally investigate the complaint, take swift corrective action, and actively maintain a respectful workplace. Ignoring a toxic work environment is a massive legal liability, for sure.
Let's pivot slightly to Section 5, Contracts and Workplace Dismissals. How is the employment relationship legally formalized at the start, and how is it handled when it ends? Well, it all starts with the employment contract. Now, while contracts can technically be verbal or implied, having a written agreement with these specific elements, your job title and duties, compensation and benefits, working hours and vacation time, confidentiality terms, and termination clauses is absolutely essential. By clearly defining these at Aurora Tech, both the employer and the employee know exactly what to expect, which drastically reduces the chances of messy legal disputes later on. But when a dispute does lead to termination, we really need to differentiate between two major legal concepts. Wrongful dismissal is when an employee is fired illegally, discriminatorily, or simply without proper advance notice. Constructive dismissal, though, is a bit trickier. It's when working conditions become intolerable or major job changes are imposed without agreement. So the crucial point is this: if Aurora suddenly imposes a major unagreed-upon salary reduction on a software developer, that employee can legally claim they've been constructively dismissed. Basically, the employer forced them out by altering the court terms of the contract. Now, if an employer does terminate someone without cause, they owe that person advance notice or termination pay. But how much? There are three heavyweights that determine the final payout: the length of time the employee worked there, the specific termination clauses written into their employment contract, and those common law principles we talked about earlier, where courts look at past precedent. Finally, we have Section 6, the remote work evolution. This brings us to a massive shift in modern HR. How does employment law apply when the workplace is literally your living room? Remember, the software development side of Aurora Tech works almost entirely from home. So, do OHS laws apply to a home office? What about tracking hours? The short answer is yes. The law still applies, but it's way harder to navigate. HR professionals are dealing with totally new boundaries right now. They have to figure out how to accurately track working hours and overtime when someone sets their own schedule. They have to balance the employer's right to monitor work performance against the remote worker's heightened right to privacy in their own home. Add in home health and safety responsibilities and equipment maintenance, and you've got a brand new frontier for legal compliance. Ultimately, employment law ensures that workplaces operate fairly, safely, ethically, and legally, even when the office is at home. But it really makes you wonder, as the line between home and the office continues to blur, how will common law adapt to protect both the remote worker's privacy and the employer's bottom line? We're going to have to watch and see. Thanks for watching the video. Please like the video and subscribe to the channel.